Happy Friday, everybody. Welcome back. Welcome back to the channel. I had a vision of a nice leisurely Friday stream where we would just kind of go through, go through emotion, look at some of the writing, look at some of the advocacy, kind of start to maybe get a feel for the lawyers, talk a little bit about some of the law that's involved and the principles that's involved. And then the week got a little crazy. The week got a little crazy. There's really no other way to put it. So we're probably going to talk about a few more things than I initially had in mind when I first set up this live stream, because of how things have developed around this motion to allow Mr. Robinson to appear at his in-court hearings in normal clothing and without shackles on. There's just been a series of developments that have spurred all kinds of collateral litigation and a closed hearing, in fact, that is going on, not quite yet, in about half an hour, I think, over there in the Utah courthouse. So I do want to get a couple things out of the way first, because it has been a busy week for a couple of reasons. And one of them that I want to get out of the way right off the bat, I did get my X account back. And so that's, it's fine. It's great. It's just another way for me to be able to communicate with people and alert people to, when I'm going to be doing things like this and the content that I'm putting out. But understandably, I know people may be a little bit hesitant to click links on my Twitter page now, given the circumstances. So I did just want to assure everybody, yes, it is me back on X. You will be getting more kittens again, and more just, kind of quick one-off commentary as that particular program is suited for that platform. Another thing that I have been doing, I have been working on a legal archive. For those of you that are particularly interested in this case, I wanted to have a way to make sure that these documents, it can just be a little bit obscure for people. If you're not a legal professional, you're not used to like navigating these systems and stuff like that, it can be a little bit obscure to find them. And certainly, just, we don't all need to buy them, just buy them and have them available for everybody. So I have spent the last few days working on putting together a legal archive of the documents that I have in Charlie KIRK, and that is right here on my Substack. So did a little reorganizing on my Substack. If you're at the home page, I just have this new topic right up here at the top, where that is going to reside. So it will just always sit at the top of my page if you are looking for it. And as you scroll through, you will see what I've basically done here is just sort of recreated the court docket. There's several documents that I didn't get because for a variety of reasons, I just kind of make a judgment call about, does this look like it's going to be substantive or not? There's tons of these return of electronic notification documents that are basically just indicating something's been filed and people have gotten email notification about it. But also I will often not get things like proposed orders, particularly if, the order that's been requested is just kind of summarily signed, because it's just going to be a duplicate of what was originally requested. So there's a few things like that through there, but for the most part, materials that are substantive, I have done my best to go ahead and get copies of those. So part of the reason why I wanted to do that is so that those of you, again, who are interested, you have it available. Also, you can follow along with it. And frankly, it'll make it a little bit easier for me as well to be able to locate and bring up what it is we're going to talk about, particularly on a day like today, where there are probably more than a few things that we're going to need to go through. So I did want to share with you, if you are not, subscribe to my Substack, you don't know where it is, you don't know anything about Substack, it's all fine. Like, none of this is obligatory, but you can find the link in the channel description. I've got this QR code that you can scan and locate it there as well. I'll just leave that up for a few minutes for folks, but I don't really want it there all the time. Like, it kind of like takes away from my cool fish, so this case, it's gotten really big really fast. It's kind of surprising to me how that has unfolded. And I guess maybe it shouldn't, because obviously this is a death penalty case. It is going to be hotly litigated. It is going to, I would presume, like, speed up pretty quickly. There's going to be motions about discovery. There's going to be motions about, all variety of procedural issues as well as substantive ones. It's just the nature of a case like this. Everybody is going to be bringing their A game and trying to position themselves the best that they possibly can. But there's also a little bit of a feeling out process with a new case. And I feel like that might be part of what is contributing to a kind of flurry of process that has been coming through. So to give you a sense of this, I'm going to show you this other thing that I have pulled up, which is this detailed court document. So when I go into the court website to get the documents, there's like a couple different ways that things are listed. And this is a docket that their system creates. And what it does is it just gives you kind of all this basic information. So, here's who it is, here's the people. Doesn't list everybody, but at least as far as the locals, it's got the local attorneys listed for the parties. And then it goes through here and gives you this detail of what's filed and what's happened. So all of these, many of these entries, these are documents. These are things that have been filed in the case. But then we also have these minute entries that these are clerk's minutes. These are like shorthand notes that the court clerk takes to describe things that have happened, hearings that have been held, conferences, things of that nature. This is kind of like a shorthand version of the transcript. It's obviously not the transcript. It's not a substitute for the transcript, but it's just a way to document the important events that are taking place at various hearings. So as you can see, I'm just scrolling through this very, very, very quickly so that you can see it's 11 pages, okay? There is a lot of stuff that has gone on and happened in this case that is just barely over 1 month old. And a lot of that has just kind of been in the last month or so. This is not the normal case. Most criminal cases, aren't death penalty cases. They aren't this high profile. They aren't going to have these kinds of legal teams involved. So it would be much more normal for cases to kind of get off on a pretty slow start. And if you don't have experience with a case like this, which doesn't look like this judge probably does, maybe as a prosecutor, but not as a judge. Judge Graff, I haven't talked about this before, but just for purposes of history, has been on the bench since May of this year. He's a career prosecutor before that. I would actually like to do a live stream that's just looking at Judge Graff and his background, and potentially also, the other parties as well, because the judge plays such an important role in how the case unfolds. And so I just find it can be helpful and interesting to get a little bit of a feel for who he is, what his background is, what kind of basis of experience he's going to bring to adjudicating a case of this nature. So I think if you were maybe, I don't know, a little naive as a judge and you thought, well, this is just going to kind of go like any other case, you would expect there's a little bit of a lull at the beginning because people have to get oriented. There has to be a discovery exchange, just kind of preliminary considerations about things like, are we going to have a preliminary hearing or not? Are we going to be, going through plea negotiations at an early stage? Are we going to get the case resolved? Uh, and so not a lot of that often requires the court to be involved with it. But this has been a very different case, uh, just partly because of its nature, partly because of the public attention to it, and so it just means a lot of little things are going to be litigated a lot more thoroughly than you might expect in an ordinary case. So I want to turn first to what kind of got all of this started. The thing that I just intended we were going to leisurely stroll through, have a little chat about. This is the motion that is the only. Well, this is the primary like substantive issue that is before the court at this particular point in time. And it's this motion that the defense filed to appear at all in-person proceedings in civilian clothing and without restraints. So those of you who followed, for example, the Bryan Kohberger case, Luigi Mangione case, very, very similar things are going on more and more in high-profile cases like this, when we know that the cameras are going to be in the courtroom, and so there's going to be a lot of imagery of the accused that's being disseminated out to the same public, the same potential jury pool that we're worried about being tainted because of, things that are being said and so forth. Well, the visual image is an important part of that as well, because we just naturally form associations with certain kinds of images. It's kind of normal to assume, oh, somebody in a prison jumpsuit, somebody who's shackled and kind of being led around in a chain gang kind of setting, it's normal to think, wow, this is a dangerous person. This is a scary person, maybe a guilty person. So we're just seeing it more and more in cases where the cameras are going to be there, that the defense teams are fighting to even that playing field, resist that type of imagery becoming prevalent. You can't avoid it. Every one of those cases that I just mentioned, Mr. Robinson, Bryan Kohberger, Luigi Mangione, the very first public image that's out there about them is them in a turtle suit. It's the turtle suit, the one where it's a suicide prevention piece of clothing. They take away all of your other clothing, and then you get put in that thing. And the reason why is because that can't be turned into a noose. That's at least the theory behind it. You can't turn it into a noose and then do bad things to yourself in your cell with that particular item of clothing. So they're often brought in for their initial appearance before they ever have a lawyer to raise this issue. Question: is this really appropriate to be presenting somebody to the public? Is this really consistent with the dignity of the court to be bringing them in this pajama looking type? I mean, it's weird looking stuff, right? Don't have sleeves, don't have long pants. It's not necessarily a great look to be in. And it's also often when the mugshot is taken after they have been put into their turtle suit. And so then mugshots typically are public records. It's, again, often one of the first images that media organizations will be able to get of this individual, an official image. And so that's quite often the very first thing you see. And that is very much the case in this situation as well. So defense attorneys want to minimize that. We want to do what we can to not just create this default assumption that you're already dealing with as the defense attorney. You're already dealing with the assumption that is extremely commonplace. Whenever anybody walks into the courtroom, they see that guy is sitting over there at the defense table. I wonder what he did. There's just an inherent assumption that because somebody has been accused of a crime, that the accusation is legitimate, that the accusation, there's a good cause for it. The prosecution wouldn't be bringing this person in. The police wouldn't be saying these things about this person if there wasn't a particularly good cause for it. And that just gets more and more exacerbated the more that we parade the individual in front of the cameras looking like a chained animal. So this particular motion, from a legal standpoint, it's not really that extraordinary. It does go a little bit further than the motion in the Kohberger proceeding did, in that it's also addressing the issue of restraints, shackling somebody in the courtroom. Very related, but somewhat distinct issue. Do you get to appear as a normal person, as any other person who is able to, for example, make bail? Somebody who's able to make bail gets to come to court in their own personal clothing, present themselves how they choose. People who can't make bail or aren't allowed bail don't get the liberty to do that. So that's kind of one of the ironies of the situation with the courtroom clothing, is that, we mentally shortcut it to this is like a dangerous person, but really it's just a proxy for this is a poor person. This is a person who has not been able to make bail. That's really what it means. You can be a rich person. You can drive drunk. You can cause somebody to you can, kill somebody driving drunk, pick up a vehicular homicide charge, a serious felony. You might be looking at years in prison, but you can make bail. So you get to sit in the audience, put on your own suit for court, and come in. Meanwhile, some guy who, is an addict who feeds his addiction by selling a couple 8 balls to an undercover cop, picks up a felony delivery charge, can't afford to make bail. He's going to be sitting there in his orange. It's not a good proxy for who is dangerous and who is not dangerous, but that's just normal. That's just natural for people to just have that association because of the visuals of it. But shackling, is a little, that one's a little touchier, right? That one's a little touchier because that's getting into courtroom security. And just how seriously do we take this presumption of innocence? If he's presumed innocent, then what's the danger? What's the danger? What's the danger from Tyler Robinson if he's presumed innocent? He doesn't have any prior criminal history. He doesn't have any sort of record, as far as we know, of violent acts. When they did a bail review in this case, they often will do like a pretrial kind of ranking of somebody's dangerousness, their flight risk, and things like that. There's started to become a lot of these like standardized risk assessments that are performed to decide if somebody should be released, what kinds of conditions should be imposed on them if they're released. And so it looks at all these different factors. They did one of these in Mr. Robinson's case. In fact, why don't I just real quickly take us back over to the Substack. I'll show you all the way up here at the top. Oops. All the way up here at the top. Public Safety Assessment Report. Okay, they did one of those. And, oops, you don't want to do that, do ya? And so you can see, oops, let me share the screen. There we go. You can see the Public Safety Assessment Report. Well, he scales pretty, fairly high on the new criminal activity scale because the new crime that he committed is a pretty serious one. It's a pretty egregious one. It is a violent one. But he doesn't have prior history. He doesn't have prior convictions. He doesn't have not even misdemeanors. He's young. Like literally, the thing that counts against him is this was a violent offense that he committed. And so when they run that through their standardized assessments, he's way down here. He's way down here, where for any other type of a case, that would be the presumption. This guy should be released on his own recognizance. Okay, that's how low risk he is. But talks about just all these different conditions that could potentially be imposed on him. But that's the default. But for this being capital murder, we would be talking about potentially releasing Tyler Robinson on his own recognizance. So, okay, that being the case, what's the risk that he poses in this courtroom? So that's the challenge with the shackling order, is because you're really asking the court to kind of put up or shut up when it comes to the principles. The principles of the presumption of innocence, the due process. Look, if we use these instruments, these risk assessments, are we going to rely on them or not? Or are they just these things that we use as justifications when we like them to do what we already want to do, and then just ignore them when they're inconvenient because they require us to actually apply the principles? See, what makes principles so difficult and why they're so hard to find is because it's really easy to apply them when it benefits you, but when it actually costs you something to apply a principle, it's much harder, and there's much more resistance to doing it. And so, yeah, the judge is there in the courtroom. The judge is thinking about his own security, thinking about the security of everybody else that's there. And I'm definitely not suggesting that that's improper. It's not an improper thing for the judge to be concerned about. But it puts him in a difficult situation, doesn't it? Because if he's presumed innocent, and we don't really have any reason to think beyond this act that he is accused of, but not yet convicted of, and in fact, no evidence so far has been presented in court, then what's really our basis for saying no? He needs to be shackled and held in this court like an animal. So let's go back to the motion here. Defendant Tyler James Robinson. This is just your basic introduction. It's grounded in his rights to a fair trial, to due process of law, the presumption of innocence, and to a reliable penalty determination under these various provisions of the state and federal constitutions. Here's specifically what they are asking for in the motion. One of the things I already like right off the bat, as soon as I read a legal pleading like this, it's extremely well organized. And you're going to see this. It's very organized and it's very clear. You don't have to flip through this thing. It's 21 pages long. You don't have to flip through this thing to get the point of what they want. It's just right here up front. It's also going to be at the end. It's just a great example of that. Tell them what you're going to tell them. Tell them tell them, and then tell them you told them. It's very similar to that. They're going to sandwich the reasons why the court should give them what they want with making it very clear and specific what they actually want. And this is more of a legal talent than you might think, because the problem with being real explicit about the remedy that you're asking the court for is it means that you might be foreclosing other things that you could ask for or that you might be entitled to. It means you got to really be on the ball. You have to have given this some thought. You have to have evaluated what some of the alternatives might be. You have to have some confidence in your judgment that this request that I'm asking for, it is the right thing. If it's not exactly what I want, it's perhaps what I'm the most likely to get. There's a good strategic reason for me to characterize it like this. I can tell you, I have read a lot of motions where you just kind of go through and you can see that this attorney or this pro se has a grievance, but they don't want to get to the point about what they want you to do about it. Like sometimes it feels like things just get filed to voice the grievance, and that's not helpful for a judge. It's not the judge's job to sit and try to sort out what you want. For you to be helpful to the judge, you need to tell them right up front what it is you're looking for and why you're entitled to that, whether the law allows it. So very clear, very concise, right up front, very organized, not hard to find. What do they want? They want, first, an order compelling the Utah County Sheriff Department to disclose any and all files, records, correspondence, and reports created by or in the possession of the department relating to defendant's motion. So they want to know, they want his jail record, basically, is what they want. They want his jail file. They want to know, where's this guy been held? Has he been, making threats to people? Has he done things? How's he been behaving? Are you giving him any medication? They want to know the full set of circumstances to understand what sort of security risk does he potentially pose? And what are you going to have to bring to argue why he might need to be shackled, why he might need to wear a stun belt, why there might need to be, multiple deputies positioned, right over each shoulder and off to the side and so forth. Because that's really what the courtroom security is about. It's about what are the alternatives? Kind of like most constitutional rights, you generally want to pick the option that is the least problematic one that solves the concern that you have. And so not everybody is going to tailor business, try to go over the table, take out her defense lawyer. And by the way, the deputy was right there, saw it, knew that was coming. Like the lawyer, you guys remember that clip? Lawyer doesn't even blink, just like, oh, and the deputy's already got her down on the ground. So that kind of thing is an option. Do you really need somebody to be shackled hand and foot? Do you really need somebody to be in a belt that will shock them, give them an electric shock and incapacitate them if they move too quickly? Not everybody is going to behave the way somebody like a Taylor Shabusiness, behaves in court. So you need to know, what, if any, signs has this guy given while he's in jail to suggest he might be like that? Hey, if there are, well, then maybe that is necessary. But from what we know so far and what's gone into that initial pretrial evaluation, there's nothing that they knew at that point. The second thing they want is a temporary order allowing Mr. Robinson to appear in civilian clothing and without visible restraints at any in-person public hearing held prior to the determination of this motion. So, hey, if we've got to put this off and he needs to be in court in the meantime, you can't decide this fast enough, then we should default in favor of his rights. And that in many ways kind of makes sense, because at least give him a chance. Maybe just give him a chance and see if he behaves in court. And as long as he behaves in court, then maybe we don't have a problem. And then the last thing the defense is asking for is a closed hearing for the court to receive evidence regarding the need for physical restraints in this particular case and the opportunity to further brief this issue. Closed hearing. The defense wanted a closed hearing. Guys, this just kind of speaks to why the public's interest in the process is not aligned with the interests of the participants. We cannot assume that either the prosecution or the defense wants us there in the courtroom. And maybe that goes back and forth depending on what the subject of the hearing is. But it's pretty normal in a case that there are going to be things come out that you wish people didn't know. You wish they didn't have to come out. You wish people wouldn't know that, regardless of which side you're on. So, yeah, the defense asked for a closed hearing here. And, is that because they wanted it? Well, if there are things in the jail file, I would imagine they probably don't want us to hear that. I would expect, I don't know what happened there. I would expect that is the kind of thing, oh, I guess we're back, that, is potentially prejudicial. I mean, I guess it just depends on what it is. And the other thing we have to balance against that is the public certainly has a right to know. And even things about decisions about courtroom security. We have a right to know how our government is making decisions like this. How is it balancing the rights of the people to know, to have information, to appear in court, with the right of the defendant to appear like a normal human being, to not be, singled out and scarlet lettered before anything has ever been brought evidence-wise into the public forum. We're entitled to know how they are striking those balances and what their reasoning is. But it doesn't necessarily mean we're entitled to know right now. Doesn't necessarily mean we're entitled to know right this second. And a big reason for that is because courtroom security and security in general, it often needs to be secret. It does. It's not secure if it's not secret. If, somebody breaks OPSEC at the jail and just blabs about here's how the jail brings people over, and here's the kinds of vehicles that they transport them in, and here's how they put them in clothing, and here's the personnel that they assign them to, and here's the time of day they do it. Well, if you wanted to cause a problem with that process, you now know everything that you need to know to set that up. It's much harder to figure out those kinds of details when they keep them close to the vest. So yeah, they don't need to tell us ahead of time, this is how we're going to handle Mr. Robinson's security in the case. We don't necessarily need to know that right now. But after the fact, well, there might be a lot of that stuff that we should know. Again, maybe not all of it. Routine practices and things like that the jail does, things that could jeopardize security in future cases. We don't necessarily have a right to know that. But things unique to this case, practices that they did in this particular case, yeah, I think we're going to have the right to know that. So going into the memorandum, guys, I'm not going to go through this whole thing. Hey, it's over there on the Substack. You guys can absolutely read through it at your leisure. But I do want to scroll through mainly just to highlight a couple of impressions that I had about the advocacy. I have said several times now that this defense team is legit. Okay, this defense team is legit, and they are legit, like not just from a resume standpoint, which was kind of clear from the moment that they entered into the case, but from a performance standpoint. This is an excellent piece of legal writing. And so I just want to kind of briefly go through and explain some of the things that I see that lead me to that conclusion. So once again, we have this great organization. One thing that they want, two things that they want. It makes it so easy to know what it is that we're talking about. They lay out their organization repeatedly and then they stick to it. And it just makes things so clear and easy to follow. You don't get lost in their argument about like, well, where were you going with this? Or where did this other thing come from? And they did this on really short notice. Okay. It's again, just not uncommon when you have to pump out a piece of legal writing real quickly. You haven't necessarily had the chance to let it simmer. And so it can end up as maybe a little bit more of just a dump, a thought dump. Like, I think it's this and that, and it might run on and it might not be all that clear, but that's just, you got time constraints and you don't necessarily have the opportunity to go back and edit it and refine it, as much as you might like. So those things certainly do happen. Doesn't seem to be a problem. Does not seem to be a problem for these guys. So the first thing he does, right? We've got the requested relief. He reiterates what it is that he's asking for. And now he starts and gives a little preview of why he's asking for these things, what he is going to be developing over the course of his argument. Why? Because it's to avoid prejudice. It's to avoid prejudice. They should get the relevant records so that we're all informed about the security issues, if any, that are present, to avoid the prejudice that the motion is seeking to avoid. Let him have this interim relief of just being able to wear his own clothes and without visible restraint. Okay, he doesn't actually need to be visibly shackled by an animal. Maybe he needs to be restrained, but not in a visible way until we can address this further. And then granting the closed hearing. Why? Because that's the appropriate venue for the court to take evidence regarding the need for physical restraints in this particular case. So they have a footnote here. Yeah, guess what? There's precedence. That's what they did in Kohberger. It's what they did. It's what they did straight off the bat in Judge's courtroom. But then this one particularly is once the case was moved over to Ada County over there in Boise, and Judge Hippler revisited it. That was the process that he followed. So first here we have the law of courtroom restraints, and they start from these very general principles and move into very specific ones. That's a sign of good legal advocacy, is the ability to refine down, to funnel down. Okay, here's why this is a due process issue in general. And then as we get narrower and narrower and narrower to the facts that we're specifically concerned with here, the specific circumstances of this situation. Due process in general, it's a broad, very general kind of idea. Things need to be fair and people need to be treated fairly. Okay, but then in what way? And what have courts said about it as we've gotten more and more like the circumstances that are present in this case? They tell us exactly where they're going to go with the law. In a series of cases, the Supreme Court has held that constitutional principles of due process and non-constitutional principles of fair administration of justice require courts not to impose excessive physical restraints on the accused who is still presumed innocent. So then they go through and show us series of Supreme Court cases. Here's what they are. Here is one of some of the briefest and most on point synopsis of the cases that I've seen in a long time. It's almost more normal when you're reading somebody's legal writing. And they're doing this. They're using a series of cases to show you the pattern, the principle, or the rule that emerges from the pattern of these cases, that you just kind of end up with these very long, run-on, convoluted sort of descriptions about what the cases are. And in fact, you might not even get a nice synthesizing type of characterization here, like here's what these cases do, here's what they've held in this series of cases. You just literally get a dump. Okay, I literally get it done. In this case, this happened and they ruled this. In this other case, this different thing happened and they ruled this other thing. And you just kind of then are leaving it up to the judge to find, well, what's the common thread between all of these things? Why does any of this matter? And so the more you can do, more that you can do the court's job for it, in terms of like, here's the point you should be taking from reading all these cases that I've cited, the better you're going to be doing. And just this ability to refine the case down to what matters for our purposes here. Okay, cases can mean a lot of things. They can cover a lot of different facts, and a lot of that, it just doesn't matter. To be able to distill down what it is about the case that matters right here and right now is a gift. It's a skill. And these attorneys have it. In two sentences here, they've explained why Illinois versus Allen matters, because this guy could be shackled, but it was because of his disruptive conduct. It was because of the fact that he was doing things that necessitated some type of control over him. Another case, one sentence, Holbrook versus Flynn. Wasn't inherently prejudicial to have police there. Unlike shackling, shackling should be last resort. And then Deck versus Missouri, due process forbids it. They make it clear why they draw on these old English law, old English common law, Blackstone's commentaries on the laws of England, presumed even back in 1769 that you should have the right to be brought to court, not shackled, without irons or any manner of shackles or bonds, unless there be evident danger of an escape. In other words, if they have good evidence that you're going to kind of try to run away, or you're going to try to like whack somebody over the head and take off, okay, well then maybe you need more restraint. But that's not presumed. It's not presumed that you need that. So only in extreme and exceptional cases where the safe custody of the prisoner and the peace of the tribunal imperatively demand the manacles may be retained. And so then Deck said that also applies to the sentencing phase of a capital case, where it's being evaluated. You've already been convicted, so you're no longer being presumed innocent. But the jury is deciding what's the appropriate punishment here. Should you get life or should you get death? And is there any possibility that that perception, that judgment might be skewed when they see you've been transformed from the guy that sat here in the suit for the whole innocence phase of the trial to now you're the guy that is in the jail garb, shackled hand and foot? They explain why. Move on to explaining why there is this judicial hostility to shackling, or should be judicial hostility to shackling. One, it's important to preserve the presumption of innocence. You haven't been convicted, and so we don't treat you like somebody that has been convicted, or we shouldn't treat you like somebody that's been convicted in the pretrial stages of the process. Two, ensuring that the defendant is able to participate meaningfully in his or her defense. If you are sitting in the court and you're wearing a stun belt, and you know that if I move suddenly, the sheriff is going to zap me and it's going to hurt, and I'm going to probably fall out of my chair and convulse on the floor, and it's not going to be pleasant. I'm going to try to avoid that. But the problem is that often in a court setting, you have to react quickly. Things have to happen quickly. If somebody is up on the stand and they're saying something and there's a problem with it. You need to communicate with your attorney immediately. Like, you need to object to this for whatever reason, or you need to know this thing so that you know what to do. Because if the attorney doesn't object right when it needs to be done, you probably lost your ability to object to it. You got to be timely with those types of things. So often in this context, you got to be quick. So you might need to move and grab your lawyer's arm. And if that sheriff sees you like move quickly to grab your lawyer's arm, you might be getting zapped. So that's what this is getting at. The ability to participate meaningfully in his or her defense is that you might be chilled. You might be chilled from doing that because you are concerned, you are scared of something like, am I going to get zapped by this belt? And 3, maintaining the dignity of the judicial process. This is one that doesn't get really talked about as much as maybe it should. But it's, in my view, one of the most important ones. And it just goes back to the theme that I bring up a lot. Brought it up several times, and so I'll just repeat it again now. There's a perspective on the criminal justice system that we have it not to protect us, the public, the law-abiding folks, from the accused, from the criminal. We have it to protect the criminal from us. Okay, because the tendency very normally, very naturally, is for retribution, is for vengeance. There's a reason why lynch mobs are a thing. And so we have this process precisely so that we always maintain the higher moral ground. Okay, this person who is before the court, accused of committing a terrible crime, they didn't give their victim the opportunity to have their say. They didn't give their victim mercy. And I hear that a lot, especially like in the death penalty context. It's so common. Oh, there was just an execution where in Georgia last night, another nitrogen gas execution. And I see this a lot. Well, who cares? That guy didn't, that guy, he should have thought of that before he burned the people. He should have, we are supposed to have the moral high ground. That is what makes us better than the guy sitting in the defendant's chair. And so if we just give in to our base desire to get immediate vengeance, our own, cruelty and animalistic barbarism, we're no better. We're no better. So the dignity of the judicial process is really important. Okay, maybe you didn't treat your victim as a human, but we can treat you like one. That's what we expect. That's the standard that we require. And that's the principle that we have to apply just as much when it's hard as when it's easy. So a lot of these cases are getting into whether these principles apply to a pretrial standard as much as it applies to a trial. The reason why the trial is important, you have the jury there. Okay, you have the jury there. And so there's a concern that the jury is going to be unduly influenced, impressed by seeing you there in shackles. Whereas a judge, at least this is the idea, the judge being more educated, more, experienced, is going to be able to put that aside and not be as affected so much by those types of considerations. So a lot of the case law that's emerged has focused specifically on the trial context and less on the pretrial. But so they do go through and evaluate some of the law that is dealing with pretrial shackling. Yep, here's we ourselves in the Washington Supreme Court. We do indeed have some law that treats it as a due process presumption that you are not to be shackled at pretrial proceedings unless there is some specific cause that requires that. So we have a whole process of having hearings and things like that relating to pretrial security if the folks want to bring somebody into the courtroom and keep them there in shackles. There has to be a justification for it. So lots of courts have started to recognize this. This applies to the judges. Why? God, look at how easily they lead us through this argument. Why? Well, for two critical points. One, these are judicial decisions and should not just be default. Security personnel get to decide them because they affect the defendant's rights, perception, and just the dignity of the courtroom. Judges ordinarily, it's understood, they get to dictate a lot of the circumstances of what happens in their courtroom. They get to control the proceedings in the courtroom. So they don't get to just default to, well, security thinks it would be better if he's shackled, so I'm going to let him be shackled. It needs to be reviewable in some kind of meaningful fashion. And second, because the reasons for the limits on such extraordinary restraints apply to criminal hearings broadly, those reasons are not limited to only what a jury may see. Look at this. Now we've got the sub-organization of these other points. So first we said court can't delegate it. So we're going to go through the case law that deals with that. And here's the case law that deals with that. There's a state case law. Here's the federal case law. Here's why. Examples: trial judge abused his discretion by deferring without explanation to a marshal's recommendation that defendant wear a stun belt in a jury trial. They use a lot of these parenthetical quotations, which I personally, I like this as a way of writing. This is achieving the same thing as that first introduction of the case law did, where we said, the Supreme Court cases have repeatedly found that, and then here's these 3 examples. You can achieve the same thing with a long list of authorities here. All of these different courts, all of these different decisions have held this. And you get to call out the specific language from it that matters, or you get to kind of, again, like summarize what it is about that case, what it held that is consistent with the point that you're making, why this case is like all of these other cases, and lead to the conclusion that you think the court needs to draw. And it runs through the Supreme Court's decision on courtroom restraints as well. It focuses on the judge and the judge's role. Judge must exercise discretion. It must be justified by a state interest. So you can't just say, sheriff thinks there needs to be handcuffs here. There has to be a reason for it, and the judge needs to review that. Second here, I got to tell you, I love the movement towards plain language legal writing. We speak in plain language. We understand plain language. And there's no reason why a legal document should be so arcane, so formalistic, so full of difficult language and so forth that an ordinary layperson can't read it. I really believe that. Like, an ordinary layperson should be able to read a legal motion and understand 99% of it without a dictionary. Okay, if you're not doing that, you're not helping your client. You're making it that much more difficult. Making it that much more difficult because the court now has to both translate what you're saying and what you're arguing, and then evaluate whether your argument is good or not. So saying it's not just about the jury, I really love that. It's plain language, very simple. Now tell me why it's not just about the jury. Because I could see, the assumption the jury's, they're lay, they're not used to this type of context. They're going to be impressed by it, but the judge would be different. No, it's not just about the jury. And here's why. Well, yes, that's where the dangers of unfair prejudice are the most severe, but the reasons apply more broadly. And the court laid out these reasons in this case. So now we're going to go through and analyze this case, and we're going to show how other cases have followed this same reasoning. It undermines the presumption of innocence. The psychological reality is that the human beings who serve on the bench are not immune to such subconscious and subliminal influence from seeing a human being in chains to protect others from him. I would argue they might actually be even more susceptible to it. And the reason why is if you go down to your local courthouse on criminal docket day, okay? Arraignments are a good one to watch because you often will get a mix of people who are in custody and people who are out of custody. And you'll see, at least in courts where they still do in-person arraignments, you'll just see there's a real distinction between you'll see people from out of custody who walk up in their own clothing, and then you'll see the chain gang. At least in the pre-COVID days before we had so much virtual court. Now you'll see the people who are personally present in the courtroom in their own clothes versus the people who are appearing virtually from the jail in their jail costume in the jail room under the awful jail lighting. So you automatically, the judge is week after week after week after week after week being presented with these classes of defendants. And these ones out here in the audience, they're more normal, they're safer. These ones in here in the jail, they're more like red flag people, right? They're more dangerous people. They're people who are repeat offenders. They're more bad guys. And I just don't know how seeing that pattern and dealing with that pattern over and over and over again isn't going to entrench those kinds of assumptions even more. That you're going to assume if I'm seeing somebody in front of me and they're in prison gear and they have the shackles on, there's a good reason for it. They're probably a bad guy. But like I already said, it's not a good proxy for is this a good guy or bad guy. It's a good proxy for does this person have money or not? Was this person able to make bail? That's all it's really a good proxy for. So I would argue not only are judges just as human as the rest of us and not immune to bias, but in this particular context, they might be even more biased. Part of that is because there's a certain inertia with these types of decisions. So when somebody comes into court and they've been released on their own recognizance, or if somebody is being held on bail, there's an inertia. There's a sense that, well, unless there is something that changes, some change in circumstances, then that's how things are going to stay. And so what does that mean? That means for the person who's already out in public and that isn't safe, the change of circumstances means somebody's going to have to prove they don't deserve to be there. And that's going to be the state. The state's going to be saying, hey, this person, their release needs to be revoked because of XYZ. They did something they weren't supposed to. They pose a risk. They were dishonest about something that led to their release. The burden of proof is on the state to show why we should change those circumstances. But now take that person that's in jail and they want to get out. Well, the inertia is you belong there. So who ends up with the burden to prove I don't belong here? The person that's sitting in jail. It's like exactly the opposite. They are presumed to be the bad guy until they can prove otherwise. So just this systemic background to how the court really works. I think it's such an important backdrop to understanding this and appreciating this, how this also poisons judges and maybe more than it does the lay people who are just seeing it for the first time when they show up for jury duty, as opposed to the judge who has seen this hundreds, if not thousands of times over and over and over again. Here are some people presumed bad. Here are some people that are presumed okay, better. Full shackles can interfere with the accused's ability to communicate with a lawyer. They can be painful, they can be heavy, they can be distracting. They can affect the trial strategy. If I'm worried about really quickly pulling my lawyer's sleeve because I might get shocked, I'm probably not going to pull my lawyer's sleeve, and that can interfere with my ability to put on a full and fair defense. Third and most important here, judges must seek to maintain a judicial process that is a dignified process. The courtroom's formal dignity, which includes the respectful treatment of defendants, reflects the importance of the matter at issue, guilt or innocence, and the gravity with which Americans consider any deprivation of an individual's liberty through criminal punishment. And it reflects a seriousness of purpose that helps to explain the judicial system's power to inspire the confidence and to affect the behavior of a general public whose demands for justice our courts seek to serve. Great summary here. This dignity is for the good of the institution and the public. The court has to be a leader on these issues. If we are going to maintain the moral high ground, the court needs to be the leader on that. They need to model the appropriate behavior. And so treating the accused as a sideshow, it's not consistent with that. It's an affront to the decorum of the proceeding. We must not exaggerate the difference between us, the lawful ones, the respectable ones, and the prison and jail population. For such exaggeration will make it too easy for us to deny that population the rudiments of humane consideration. Very easy to dehumanize the others. As soon as we can other them, as they say, very easy to dehumanize them, and then they deserve bad treatment. And we have now become what we have a legal system to protect us against. So a lot of focus on the dignity of the court. So now, what are the factors to be considered in the need for a hearing? It's only permitted as a last resort. Only where justified by an essential state interest specific to each trial. This is that narrow tailoring, that least restrictive type of means that we see in many areas of legal analysis. When fundamental rights are concerned, you should intrude on those the minimum amount necessary. So there needs to be a case-specific and individualized assessment. Can't just default to the person is accused, therefore they need to be in handcuffs. It must have some relationship to disruptive, contumacious, and stubbornly defiant defendants. You need some indication that you got to tailor your business here. That's who the shackles are for. Okay, that's when it's going to be justified. Everybody gets that. Nobody should be able to jump over and stab their defense attorney with a pencil or whatever it was she was trying to do. That's not what court's for either. And the people that participate in it have a right to be safe from stuff like that. But you need some indication that that's who you're dealing with. We don't have any indication so far that Tyler Robinson is anything like that. Before a court may shackle a disruptive attendant, it must first pursue less restrictive alternatives. Always the last option. So that's the restraint. That's the restraint, the shackling part of the motion. Why they think this is what we've asked for. We've asked for him to be free from those shackles. And if he is going to be shackled, there needs to be some evidence presented that justifies it. And so to the extent that that implicates stuff that shouldn't be in the public eye, it should be a closed hearing. That's the defense's perspective. So then the second part of the motion that's dealing with the jail or the prison clothing, again, very similar. This one is not so distinct, I guess, so different, novel compared to Kohberger and Mangione and stuff like that. We kind of understand the reasoning behind this. But I still just like how they've laid this out, how they've explained it, the writing behind it, the use of quotes. As the Colorado Supreme Court found in the very first case in this country prohibiting trial in jail or prison clothing, the mind of a prisoner would be as much disturbed and his mental faculties as much confused and embarrassed by carrying on his person such brand of incarceration as requiring a prisoner to wear the word county jail branded upon his clothing. Scarlet lettering. Scarlet lettering. And is that going to affect you? Is that going to be embarrassing? Is that going to bring you down? Maybe affect your motivation, maybe affect your self-esteem, maybe affect your confidence. Yeah? Yeah, I definitely think it can. So you're entitled to your indicia of innocence, but unlike the physical restraints that actually have a purpose, jail security, compelling an accused to wear jail clothing furthers no essential state policy. This is a matter of convenience only. It's a matter of convenience to jail staff. Requiring you to go to court in jail clothing is just easier, because if they're going to wear some other type of clothing, then that clothing has to be brought in. It has to be, examined to make sure it doesn't like have drugs in it. That's a whole new thing now, like the soaking materials in drugs. It's happened with paper. There's been all these scams that went through the Washington prison system where people were stealing not stealing, but just like looking up lawyers' contact information and mailing like fake legal mail that purported to be from the lawyer, but it would actually be paper that was like dipped in drugs. It's a way of like smuggling drugs into the jail. And I heard about this several years ago when a girl that I used to know, I used to work with, I mean, I still know her, but a girl that I used to work with a little bit more closely, she had that happen to her. Somebody used her credentials to send a fake legal mail. They intercepted and it was meth, found there's meth in the paper. So, they got to check stuff like that, make sure that it's not contraband. But then they also just have to have the logistics. Like jails like to operate on routine. It's much easier. You've got your regular schedule and things are always very predictable. And now if you've got to break the routine for somebody in particular, you might have to have another staff person in for that. You might have to have another room available for that. If there's another room available, you might have to have some other security considerations. So it just creates an inconvenience. That's the reason they don't want to do it. But it doesn't help anything with the court process to have you sitting in there in jail clothes. And now the application of the law to this case, I mean, they've already told us, right? Through the way that they've argued, they've already told us, here's how the law applies to this case. But they're going to get even more specific now, okay? They're going to tie it in even more clearly. He should be permitted to don the indicia of innocence. Why? We've got ubiquitous internet access and unrelenting media attention to a high-profile criminal case. That's him, right? That's him. At least in theory, there have been eyes so far. Maybe not as many eyes as I would have expected. We'll just see how that continues to flesh out. But just increases the likelihood his images are going to be out there, unlike just the random person who's brought into jail on any other Friday afternoon. Mr. Robinson is much more likely to have his images publicized. It's a death penalty case. Also very important to make sure that you are as fair as possible, that you are not doing anything that threatens to tilt the scale unfairly, because this is the most significant penalty that's at issue. This is the worst thing we allow our government to do, is to kill somebody. So it needs to be spotlessly clean. It needs to squeak. It's so clean. So then in this particular case, let's describe it. His first appearance, September 16th, 2025, from the Utah County Jail, streamed live and covered by media outlets the world over, including the BBC, Al Jazeera, ABC, CBS, NBC, Newsweek, NPR, the Daily Mail, Fox News, CNN, and countless others. This one appearance generating approximately 18,000 news search results. His physical appearance alone was and is subject to endless scrutiny and speculation. You Kohberger veterans are going to remember that one too. Like everything becomes a body language analysis, an expression analysis, a reaction analysis. Like, ooh, we're just going to fixate on him and what did he do? You know, what did that mean? And what it means is going to be read through the lens of what do you want it to mean? What do you want it to mean? Do you want it to mean it's exonerating or do you want it to mean it's inculpatory? That's how you're going to see it. One article described him during his initial appearance as emotionless. We heard that with Kohberger too. Emotionless, staring blankly ahead and sporting slightly mussed locks, several days worth of facial hair, and wearing a green suicide smock. Yeah. The turtle suit. Turtle suit is what I put on the thumbnail. That's the image. That's the image that's out there. So in his particular case, there's a lot of pervasive imagery of that. Here's something you don't often see in trial level advocacy. You see this a lot in appellate advocacy, but especially highest court appellate advocacy. You see things like the Journal of Police and Criminal Psychology being cited to the Supreme Court because that's the court that's most likely to be interested in policy and what should the law be. We're dealing with an issue where maybe it's not crystal clear how a particular law is to be interpreted, exactly how it's to be implemented. And so they're interested in what are the implications of one way or the other. And so it's common to cite sociological type of research in those contexts. You don't often see it in a trial setting, but we've got some of that here. Empirical study finding that a defendant dressed in a prison jumpsuit versus a dress suit was seen as more aggressive, and that the perceived aggressiveness result in defendants being found 5.27 times more likely than mock jurors in the formal attire condition to render a guilty verdict than a not guilty verdict. Your clothing alone, more than 5 times more likely to lead people to think you're guilty. Another study, effects of pretrial publicity on jury verdicts. So these big picture considerations that should this case end up in a posture of getting reviewed by the Supreme Court, this is the kind of thing they're going to be thinking about. So judge, you might as well be thinking about it now yourself. In the face of worldwide scrutiny, permitting Mr. Robinson to wear civilian clothing for court appearances is a minor inconvenience compared to the already present concerns with securing a fair trial before an impartial jury. What I love about this and the way that they're expressing this, I find this a highly persuasive point. It's highly persuasively stated. Why? Because it's not hysterical. This isn't the sky is falling. This isn't over the top emotive. This is pretty dry, but straightforward and to the point and strong. There is worldwide scrutiny here, but what's the trade-off? It's a minor inconvenience. It's a minor inconvenience compared to everything we already have to be worried about. Everything that you, judge, relied on to say, you know what? There's such a risk here. We need to gag people. We need to gag people. There's such a risk here. It's the same justification. What it means in terms of needing an individualized determination. Here's the case law. Just reiterating some of what we were already told. Here's his situation. 22-year-old lifelong resident of the state of Utah. He has no criminal history and upon information and belief has been polite, deferential to jail staff and without any disciplinary issue while in the Utah County Jail. But that's definitely why they want his file, because that's upon information and belief. And so until you know, these are experienced lawyers. You are always very, very cautious about, well, you learn. Most people learn, hopefully not the hard way. Hopefully you don't get burned too badly by making too definitive a representation of fact to your court that's just based on what your client told you, what your client's family told you, what somebody aligned with the defense side told you. With really anybody, honestly. You kind of gets a little hard to trust. After you've been burned really badly telling your court, Your Honor, my client has lived at this address for 10 years and he's maintained steady employment. And then the, prosecutor brings in his lease agreement that expired, 5 years ago, and his eviction paperwork and a statement from the former boss about, why he was terminated for whatever. You just learn not to get out over your skis about stuff like that. So this is the information that they have, but they want the file to be sure that they know before we are going to say definitively, okay, this is what we understand, and it's also backed up by the court records. There's no records of complaints. There's no records of disciplinary issues. The fact of the accusation alone is not sufficient to justify the shackles, so they need something else. The court should allow him to exercise this right without looking like a bear on a chain. This is clever because this is allowing them to be a little bit more extreme in their language. But they're quoting a case. They're quoting the case. So it's not them making it up and saying, it's this bad. It's so bad. It's the worst thing in the world. No, a court, an appellate court, a federal appellate court actually said this, and we're just quoting them. That's how they see it. The world is watching. And so finally, given that court and jail security protocols and prejudicial materials and opinions not admissible at the guilt phase of this trial will be evidenced at the hearing, it is reasonable and appropriate for this court to close those proceedings and maintain the transcript evidence and pleadings, commenting thereupon as private in the record. I would argue at least for now, at least private for now. Does that mean we should never get to see any of it? I don't know about that. I really don't, because things can be redacted. Transcripts can be redacted. And so we'll wrap up with this before I talk about that a little bit more. But so that's the motion, guys. That's the motion. Very well done, I thought. Here's the exhibit, is that Ada County order from the Kohberger case. These guys are legit. Telling you, these are legit lawyers. These guys are very skilled. They know what they're doing. They are on the ball. So that was the motion that got filed, and I thought that was all that we were going to be talking about. But then it turns out things got a little messier than that. So what I'm going to do now, I'm going to take us back to that detailed docket so I can kind of walk us through what happened here. Walk us through what happened. So this is early stuff. This is before the motion is filed. I want to stop and pause here. Okay, because here is where we're going to start. This minute entry on September the 26th of 2025. This telephonic conference. These guys got together Off the record. Off the record. The attorney, Nestor, defendant wasn't there. Okay, defendant wasn't there. Judge was there. Clerk was there. And it was unrecorded. What happened? The matter comes before the court for an unscheduled conference at the request of counsel. This proceeding is not recorded by FTR or WebEx. There's no record of this other than these minutes. Counsel addressed the court regarding issues and concerns relating to Mr. Robinson's appearance in open court. A discussion ensued regarding counsel's concerns, including matters of safety. Really sounds like this is exactly what they were talking about, that they brought this to the court behind the scenes in this unrecorded teleconference, not in open court. Not clear why you would do that. Not clear why you would do that. It's not, okay, so it's not uncommon if everybody is on the same page to go to the court and get things done without a court hearing. Just by stipulation, agreed order, something like that. But that's clearly not the case here. This isn't we're going to the judge with an agreed order that all he needs to do is sign. There is some type of substantive conversation that is happening here. And a discussion ensued regarding counsel's concerns, including matters of safety. It doesn't sound like we're just talking about, hey, heads up, the prosecutor and I have talked about this and we aren't going to be able to reach a resolution. And so we probably need to litigate this before he's brought back in court for the next hearing. You could do that. You could do that in a letter. You could do that. I don't want to say do that in an email, because emails have a habit of not ending up in the record. They are not an appropriate way to be talking about substantive issues in a case, unless you're, gonna go to the trouble of making sure you file them so they are part of the record. But the problem is nobody almost ever does that. So you could deal with that in a letter, just a heads up, this is going to be an issue. It doesn't seem like it's that either. Right? Because we're talking about a discussion ensued regarding not just your concerns, but also matters of safety. They talked about, well, is he dangerous? It seems like they had a substantive conversation behind the scenes that was unrecorded. Well, I don't love that at all. I don't love that at all. As the appellate attorney in my old life, this is kind of a nightmare. If there were going to be some type of issue about we need to litigate the fairness of this process because he was brought into court shackled, visibly shackled, and in jail clothing for his pretrial proceedings, and these were televised all over the world, and this tainted the jury. If that's going to be an issue on appeal, I want a record of everything related to that. And we now have no record of this conversation besides these minutes that just tell us it happened. I don't like that at all. Not one bit. But then there's this next issue. Court addresses counsel and discloses prior employment with the county attorney's office. Counsel affirmed that no conflict exists. We know Judge Graff is a career prosecutor. That's his background. Not unusual for judges. Although ironically, in the 4th Judicial District of Idaho, that is in fact abnormal. It's one of the things I'd like to just devote a specific live stream to and talk about the judge and kind of the context of the judge ending up on this case, who some of the other options were. But he's got history with the county attorney's office. So the county attorney's office, these guys are parties to the case. But counsel affirmed there's no conflict. You don't have to get off the case just based on that prior representation. So legally, that's accurate. It's generally accurate. I mean, you wouldn't have judges if they weren't allowed to have had prior professional relationships with other lawyers. Those other lawyers in the community are going to always appear in the court of the judge who's drawn from that community. Uh, they can't have financial relationships, financial ties. They can't still be part of a law firm. And there's a little bit more of the more ambiguous appearance of impartiality is some of that, but also there's a lot of trust placed in the judges to evaluate for themselves. Look, am I going to unfairly credit somebody that I know from my past job over somebody else? Because of the fact that I worked with this person, I know this person really well. Am I going to be unfair to the other party? It's a legitimate concern, isn't it? But we really just defer to the judges to kind of decide that for themselves. If in any particular case, hey, do I know this guy? I don't know how to say his name, Chad Grunander. I worked with Chad Grunander for 10 years. Am I going to be unfair to him? They defer to the judge to make that call. And we just definitely hope that they have the character to be fair and principled when they're asking themselves those types of questions. So, yeah, legally there's no conflict, but this does kind of hint at maybe a little not legal conflict, but just colloquial conflict going on in this WebEx conversation. Doesn't that? If the judge is having to come out here and we're having to talk about whether the judge has a conflict of interest over this conversation that we're having about court security and concerns about his right to a fair trial, that sounds like that might have been, if not a heated conversation, at least there was some disagreement. Doesn't it sound like that? It definitely sounds like that to me. And so it's just one more reason why it's a little alarming that there's no record of this conversation, what actually happened. So in anticipation of motions being filed concerning the defendant's appearance and in consideration of the late hour, counsel have agreed that Mr. Robinson will appear virtually for the hearing scheduled on Monday, September 29th at 10 o'clock a.m. So this is happening, what, like Thursday before? No, the 26th. This is happening the Friday before. Friday night before, they're coming in to talk about, hey, we got this hearing. What's he going to be wearing? Rather than deal with it over the weekend and give him time to litigate it and so forth, everybody agreed, we'll just do a virtual. He'll appear virtually. And we didn't even see him on the screen, right? At that September 29th hearing, we didn't even see him on the screen. He was just kind of there, probably with a audio video feed, but he wasn't shown. So then we got all these other things that get filed, mostly relating to the attorneys coming on board. These are the minutes from the hearing that we did see, the September 29th one. They set the next hearing for next week. We'll be watching that one, guys. Yes, we will. Oh, but there's more that we'll also get to. So this is all stuff we kind of know about already. Here's another telephonic conference. Okay, another telephonic conference on September the 30th. So now 4 days later, okay, September 26th, we had this first one. 4 days later now, we have another one, but there's something different here. Yeah. We recorded this one. We recorded this one. This is kind of what I was talking about at the beginning, that there might be a little bit of a sort of feeling out stage or process with this case where kind of maybe takes a minute to sort out, like, how are we supposed to be doing things here? Somebody, it occurred to them, you know what, that was a really bad idea that we had that conversation not recorded. So recorded the next conversation. And in fact, this whole conversation was about the fact that the last one wasn't recorded. This conference is just about saying that we're going to agree that as long as there's a minute order that we just read that describes what happened at that last phone conference, that's going to be fine for record purposes. Nobody's going to make a stink or like say there was a big error or something like that. Counsel's agreeing to it. Boy, does this remind me of Judge. Boy, does this remind me of Judge. Remember, one of the like best talents that Judge had was to be able to talk people off of their positions. He was the one where it stood out to me the most was with the gag order hearings. Do you guys remember the gag order hearings? The press had that attorney, Ms. Olson, I think her name was. Very, very impressive from, a legal standpoint. She's from a good firm. She's very articulate, well argued, knows the case law. She's like, everybody knows she's the best lawyer in the courtroom. And Judge is able to talk her into basically, well, if we tweak this, could you live with that? He's able to negotiate her off of her position and into accepting something. And the reason why that's such a good skill for a judge is because as soon as the party has said, yeah, okay, I can live with that, I can accept that, they can't challenge it anymore. You can't say, yeah, that's okay, and then go back on appeal and say that was wrong. That's invited error. You went along with it. If you really think it's error, you got to stick by your guns and say, I appreciate the judge's efforts to resolve this, but just as a matter of legal principle, I don't think that that's correct. I don't think we can stipulate to that. The public has rights. The press has rights. Whatever. You got to play the game and stick to your guns. So that was a big skill that he had, to be able to take appellate issues off the table by being able to talk people into abandoning their position, into accepting a compromise, accepting a middle ground. That's what this gives me vibes of, right? Because they're not going to be able now to go back and say the absence of a record of that telephone hearing is some kind of an error. Counsel's already agreed that will suffice. That's okay. And by the way, that one, we recorded it. So there is a record of that concession being made. Very clever. Very clever. Okay, so moving on. Here's where we start seeing the motion getting filed. And there's a lot of this collateral stuff because it's a long motion. It's longer than the rules ordinarily allow them to file. So it isn't just we file the motion. We also have to file a motion for permission to file an overlength brief. There is apparently a process to submit that without a hearing, without a response, from the state. So there's stuff we have to file related to that. It's just basically, we had to file this massive volume of things. That's really just this motion to be unshackled. All this collateral stuff that went along with it. And so then other things are happening in the meantime. And then the next thing that happens, 10/14/2025, we get this interim order. Interim order on the defendant's motion to appear in civilian clothing without restraints. That's this, guys. That's this. And so if you read my Substack, saw my X, saw my YouTube post, that's this order. And so what he said, Based on the fact that this motion is not going to be fully briefed and decided prior to this hearing, he had requested this interim relief. And so he wants to expedite so that we can try to get this resolved. So he sets a briefing schedule. Mr. Robinson must serve his motion on the Utah County Sheriff's Office no later than October 15th. State must file its response by noon on October 20th. Mr. Robinson will have the end of the day on October 22nd. And then the briefing, must address the specific things that are being requested. Seems pretty normal. Okay, briefing schedule. Not really that unusual. And then we get this here on the 20th. We get this here. Private. The response is private from the state. But then they also file the reasons why they think that their response should be private. And so that's this right here. Motion to classify as private, the response. And here they're talking about the October 13th interim order permits the sheriff's office to file a response as a sealed document if it contains secure information. See October 13th, 2025 interim order. This is October 14th. This is October 14th. And this doesn't say anything about the sheriff's office filing a response or sealed or anything like that. It doesn't say any of that. So the state is addressing something else, something that is not this interim order, that is the interim order on the docket. And so they're basically saying, hey, if the information from the security measures, okay, is dealing with secure information, then it should be private, not sealed. Sealed means absolutely nobody except the court can access it, but private means that we, the public, don't get to access it. And so then they acknowledge on October 14th, then the court entered on the docket this modified interim order. Modified interim order. Well, it's just an interim order. It doesn't say it's modified. Ordering the state, the sheriff's office. Ordering the state, the sheriff's office. No. It orders the state to file its response by noon on October 20th of 2025. But the state, the sheriff's office, to respond to defendant's motion. No, it ordered the state. Like, I don't know. This doesn't belong here. Block that out. The sheriff's office was not ordered to respond. The docketed October 14th interim order omits the reference to allowing the response to be filed under seal, but they believe it was a mere oversight. And here we are again, the state and the sheriff's office. The state and the sheriff's office are presenting themselves as unified, filed by the attorneys for the plaintiff and the Utah County Sheriff's Office. So as far as the prosecution is concerned, we are the same people as the security folks. We are the same. We're the same ones. And so the judge immediately, same day, signs the order. Yes, your response gets to be private, and we're going to handle it as private. And so then the very next day, we get a motion to strike. I have to pull this one up because I did not get it up beforehand, but fortunately I have this really handy legal archive over here. It makes it very easy to just access and find these things. So here it is. Let me make it a little bit bigger. Defense files this motion to strike. Okay, so this wasn't anticipated in that briefing schedule. Motion to strike, no. Because now that throws everything off. If we don't consider the state's response, then we don't have a response from the state, and we have to reset the deadlines, and we're like even less likely to be close to resolution by October the 30th. So here's the reason for striking it. Utah Sheriff's Office doesn't have standing to respond. They are not a party to the case. They're not here to advocate. They are literally a witness. They are a witness. The Sheriff's Office is a witness. They're the ones who would be giving testimony about what's the standard, what's elevated need given the profile of this case, what are the options that are available, what has, if anything, has Mr. Robinson been doing in custody that creates an individualized risk, what has he been saying, how has he been behaving, etc., etc. They're a witness. Further, where Utah County Attorney's Office has not sought to distinguish its own responses from that of the Sheriff's Office, the pleading should be stricken in its entirety. You're not the same person. And so if your response is just melding your position with the position of somebody who doesn't have standing to have a position, then your response is improper. We can't sort out like what should be yours and what should be theirs. And so that's the general gist of their argument, that the Sheriff's Office here, they need to be here as a witness. And that's kind of important because if you're a witness, you get on the stand, you take the oath, you are sworn, you give testimony, you present documentary evidence. Those are formal exhibits that are admitted into the record. And then those are treated a certain way from a legal standpoint and from a review standpoint. When you're a party, you just make representations. And you do that based on your obligations as an officer of the court. The attorneys do anyway. But it doesn't carry the same weight as sworn testimony and sworn evidence does. And so if they're able to just get their factual basis for what they want to do before the court without having it sworn, number one, that's kind of convenient. But number two, it creates a problem in terms of, is it proper for the court to rely on that at all? Like, is that is that even fact? Allegations are not fact. Representations of attorneys are not fact. Facts are what the court finds based on admissible evidence. And so if they don't present admissible evidence, there's nothing for the court to find. There's no basis. It's just a very messy, sloppy, informal way to be handling the adjudication of an issue. But then they go on to call out more sloppiness. The court's two interim orders seemingly recognize this issue. What two interim orders? There's only one on the docket. Well, here's what happened. The first order issued on Monday, October 13th. The court ordered both the Sheriff's Office, i.e. the Corrections Division, I think they also meant to include, and the Prosecutor's Office, to file a response by noon on October 17th, 2025. See Exhibit A. And now this footnote, just calling out what the situation is. The October 13, 2025 interim order received by defense counsel does not appear in the court docket and is not referenced in the October 14, 2025 interim order. Defense counsel interprets these events to mean that this court intended the interim order on file with the case to be controlling. This is a mess. This is a mess. This shouldn't be an issue. Let's go ahead and just flesh out exactly what it is that happened before we rant about that a little bit. The court also ordered the state, i.e. the prosecution, to respond by the same date. However, on October 14, 2025, the court modified the order requiring only the state to respond. It appears that the court recognized that it would be inappropriate and impermissible to order a non-party in a criminal case to respond to a defendant's pleading. The sheriff's office, UCDAO, seemingly did not identify this distinction in its filing, arguing summarily that the sheriff's department has standing to respond where the court ordered it to. This is incorrect. So here's the problem we have. Okay. The court signed an order on the 13th and sent it out to everybody. And then the next day, it filed a different order, and it never filed the first order. And so nobody knows what that means. And now they're having to have this collateral litigation over what does that even mean? We don't know what this means. And this is so extremely messy because it's so unnecessary. And let me tell you why. Okay, so first off, this whole I'm going to email something out to the parties that is not filed. This is the digital version of having the phone call that doesn't get recorded. The email conversations about the case should not happen ever unless you have a rigorous and well-enforced policy of filing your frickin' emails into the court file. Because substantive conversations about the case need to be on the record. What am I ordering? What are the arguments? If this stuff happens in email that's not part of the court record, the case is being litigated outside of the public eye. And now we have a court closure problem. We have a public access problem. We have a First Amendment problem. Because that's not how courts operate in the US. Courts operate openly. Courts operate on the record. We don't do things by backroom email conversations. So unless you have a real good habit of making sure that those conversations always end up in the record, you should not be having them. For heaven's sakes, what email is for when you're talking to the court, it's to say, here's my schedule. Here's when I'm not available for a hearing, okay? We've got 4 lawyers now on the defense side, 5 lawyers on the prosecution side, the judge, the clerk. We got a lot of people whose schedules we got to coordinate if we're going to be trying to get anything done in this case. That is a perfectly normal use of email because people's schedules don't matter to the decisions that are made in the case. The substantive decisions, the judge is not granting or denying a motion based on somebody's schedule. So administrative, procedural stuff like that, totally fine to have those types of conversations by email. And, makes a lot of sense to do that. It's much easier than trying to get 9 people on the phone one by one. But you cannot be litigating the case. You can't be substantively discussing the case in the email. That has got to be a hard line unless you want your emails to be filed in the court file. If you're okay with that and you make a practice of doing it, then okay, your risk. But this is not good. This is not good. And that's the first problem. That's the first problem. They're emailing substantive stuff behind the scenes off the record. Never gets filed. No idea what the context of this is. Maybe this is just an email attachment. Okay, it's minimal. We don't have any idea because it's not part of the freaking record. We don't know if this is part of a bigger conversation. But then you also just substituted A different one, a completely different one, is the one that you actually filed without notice to anybody. You just kind of swapped it out and did something else. So kind of shows the problem. What when you did this by email in the first place, how are you going to communicate what you're doing now unless you are communicating with them by email about substantive things, which you're not supposed to do unless you want to be filing your emails. So there's no way now to explain, here's why I'm putting in this order instead of this other order. Substantive case conversations. So instead, he just files this other order. Now, here's the thing. Yeah, he changed it, and I don't know his thought process for it. Doesn't seem like the lawyers know his thought process for it. They're just kind of guessing. So he changed it, and we don't know why at this point. But honestly, like, that's fine. Judges can change their mind. It's honestly kind of great when judges change their mind, when they recognize, I could have been wrong. Maybe I didn't get that one right, and I will be a man. I will step up. I will fix it. I'm not just going to bury my head in the sand and pretend that this wasn't an issue and just, let my wrong order stand because, by golly, I made the decision. I'm going to stick with it no matter what. No. It's good when judges change their mind, but we need to know that that's what happened. The thing is that there's a very easy way to show us that that's what happened. You file both of them. You just file the October 13th order that you initially sent out to everybody, you file it, and then your October 14th one, you call it an amended order. You just amend the first order with an amended order. And then it's there in the record, and it's really clear what you meant. I meant for you guys to follow the second one and not that first one. It's crystal clear. And I'm really baffled, racking my brain for why would the judge not do that? Why would you not do that? Why would you not do that? Are you embarrassed that you changed your mind? Like, that's not anything to be embarrassed about. That's good. That's good judicial stuff. That's good. It's totally fine. Everybody is wrong from time to time, and it's so much better to catch it now and fix it than to dig in and be corrected on appeal. It's the last thing anybody ever wants in a capital case, is to go through all of that and then have to do it all over again because of one stupid mistake early in the process that could have been fixed real easily. It's the last thing anybody wants. So I just don't get it. I just don't get it. Why would you not just file both of them? I'm at a loss. I'm at a loss. For some reason, the court didn't want that first order to be official, to be on the docket. It was official enough to send out to the parties as like, here's my order, but not official enough to document as part of the record. I just don't get it. My concern, and the reason why I hope I'm wrong, but it's just my concern, is that, the court saw this and decided maybe, oopsie, maybe I did that wrong. And then is trying to save face by just, well, we'll just slip in this other order. We'll just go ahead and put in this other one the way it should have been, and never really address my oopsie, the fact that I made a mistake. I hope that it's not that, because I would not want to think that a judge is going to play fast and loose with the record just for the purpose of saving face over something that is nothing to be embarrassed about. It is a good thing. It's a good thing. Judge, you changed your mind. That's freaking awesome. That is a great quality in a judge. Always be open to doing that. It's nothing to be ashamed of. But I just can't think of any other reason. I really can't. I really can't. It created this mess. It created this mess because nobody knows what he means. Nobody knows now if the sheriff's office is responding as a party or not. Nobody knows if the October 14th order is the one that's effective or the October 13th is the one that is effective. The defense is especially concerned because they are treating themselves as the same people, but they're not the same people. The Utah County Attorney Civil Division represents the sheriff's office. The district attorney's office, the county attorney's office, represents the state of Utah, we the people, in prosecuting individuals accused of criminal offenses. We have very specific roles that we perform here. From a conflict standpoint, it makes sense that a different entity represents the sheriff's office to protect those particular interests in all aspects, while the prosecutorial division represents and protects the interests attendant to a criminal trial, including its responsibilities to a criminal defendant. Prosecutors have duties to criminal defendants just as they have to everybody else in the public. They also represent criminal defendants on all of our behalf. And so their interests are not always going to be aligned. And their purposes are different. Their purposes are different. So treating them as one and the same is a bit of a problem. UCAO appears to have abdicated its role as a party in this case to counsel for the sheriff's office. It is not appropriate for UCAO to assume a role as counsel for the sheriff's office and allow the sheriff's office to assume standing through UCAO's participation as a party in this case. Same thing, the sheriff's office is not the prosecutor. They shouldn't be fulfilling the prosecutorial role. They are a witness. They should be showing up in court to raise their hands, take the oath, provide what they know, provide the documentation if they have it. That's their role. So here's the exhibits that they submitted. Here's the interim order, the one that never made it onto the docket. Well, it's sure on the docket now, isn't it? As an exhibit to this motion. So if the goal was to like keep this thing off the docket, the defense was like, nope, we're not doing that. We will be making the record now. Maybe the telephone issue, the telephone conference that didn't get recorded, maybe that was like the warning that the defense needed, that this fast and loose stuff with the record, we can't tolerate this. We have to nip this in the bud. We are going to call out what happened. We are not going to pretend this didn't happen. It did. And we're going to make sure that our record reflects that it did. So here's the original order that went out. Corrections Division required to file a response by noon. They can file it as sealed. Upon request by the parties, may consider a motion to view the response in a controlled setting. Any view will be for attorney's eyes only. This was his original process. He wanted this writing from the Corrections Division. And, maybe the reason, like I kind of talked about before, that he realized this isn't going to work is because this is not going to be sworn testimony. A legal response, a legal brief from the Corrections Division, it's not going to be sworn testimony subject to cross-examination. This is not going to be the kind of thing that you can base findings on for purposes of deciding whether Mr. Robinson should be shackled or not. So, yeah, I think that's wrong. I think it's good to reconsider that. I think that this is not the appropriate way to proceed. So I think he was right to correct it, assuming that's what happened. You know, here's the date, 13th of October, day before. Then this other exhibit here, the emails between the people, the defense sends this one. Hi, Chad. Any idea why the judge changed the order? He didn't bother to tell them. They get this order sometime in the afternoon the next day, and they don't have any idea why it got changed. Neither of them know. Chad, no idea. We just saw it come in. So that's why they're in the dark, because this is a very, very sloppy, fast and loose way to be playing with the process in the case. So then I see this come up in the docket. Closed hearing. This is it. This is the one it may be done by now, but this is what's going on this afternoon. Closed sealed hearing. Closed sealed hearing. Just, kind of late notice, real fast. Everyone's going to go into court. This sure looks like he granted that interim relief that the defense was asking for to have a closed hearing. But I don't know, because there's no order on the docket. I don't know. I don't know what the scope of this is. The closed hearing implicates a whole other series of issues with the right of public access. This is something, boy, we went through this with Kohberger. We really went through this in Delphi. Oh my Lord. Did we ever go through this in Delphi? But this is an issue that there is not really a whole lot of legal dispute about. The right to be present in a courtroom for pretrial criminal proceedings is extremely well established. And so if you're going to close the courtroom, once again, we're under those same standards. Anytime you're talking about limiting some fundamental rights, we're under those same standards of it needs to be the least restrictive way possible. Like, we understand, yeah, there are security issues. There are things that could jeopardize safety in the courtroom. It could jeopardize Mr. Robinson's safety, sure, certainly, for people to know the movements and what he's wearing and stuff like that. But that doesn't mean you get to wholesale close everything relating to whether he should be shackled or whether he should be in civilian clothing. Variety of these other things that are filed. Now, where? Oh, it looks like. Did they pull it? I got to look back through here. Here's their private response. The interim order. Discovery protective order. Motion to classify as private. Order granting motion. Order granting motion to preserve. Here we go. Order for transport. Let me go ahead and pull that one up. This was what I saw on the docket actually before I saw that they were going to have a closed hearing. Because I saw this and I'm like, what on earth is this? Didn't know there was supposed to be a hearing. Hereby ordered that Jaxson Thomas Fox be transported for a preliminary hearing on Friday, October 24, 2025 at 3 p.m. before the Honorable Judge Tony F. Graff. The hearing will be held in courtroom 4B of the Provo 4th Judicial District Courthouse. Filed under Mr. Robinson's caption, his case number, signed by the judge. This is the first thing I saw. So I'm instantly like, oh, are we having a hearing? Because that's new. That's new. I haven't heard about a hearing. And who on earth is Jaxson Thomas Fox? Who on earth is this guy? A preliminary hearing? We don't mean like a preliminary exam preliminary hearing, do we? That's the one we don't have scheduled yet. That's the one where the state's got to put on their evidence to show probable cause. Got to substantiate the indictment, show that they have the evidence to back it up. So what on earth does this order mean? Well, I was able to find out who Jaxson Thomas Fox is. And Jaxson Thomas Fox is a guy who has been in jail in Utah County since July on child crime allegations. If you go find the Substack article I wrote the other day about all this, I've got the article that I found linked about it. We're on YouTube, so I don't want to get into too much of the detail about what he's accused of. But it's a 13-year-old girl. There's previous instances, stuff on his phone, secret changing room photos. These are all the allegations against Mr. Jaxson Thomas Fox. So what does that mean? Who knows? Who knows what that means? My guess, which is complete speculation, but just consider it informed speculation based on, the context and what I would anticipate being at issue in a hearing about security, is that this is a jailhouse informant. This is a snitch. This is a guy who's been in custody with or very near Mr. Robinson and is going to go in and testify, oh, he said this or he behaves like this or something like that. That's my guess. That's if this isn't just a mistake. This is just a mistake. This isn't supposed to be in Tyler Robinson's case at all, or it's supposed to be somebody else. Like, I don't see a real high probability that this was meant to be an order to transport for Mr. Robinson and they just accidentally entered Mr. Fox's name on it. That seems unlikely to me. So what happens? It's not uncommon. You reuse the same forms over and over again. You already have an order to transport for Mr. Robinson. You've done it twice. There's 2 of them already in the docket. You just use that as your template. But then if you're using things like that as a template, yeah, sometimes you make errors with cutting and pasting. You forget to change something that needed to be changed. But the thing is if this order was meant to bring Mr. Robinson over, Mr. Robinson's name would already be the name of the person to be transported. You wouldn't need to be changing the name. So why would you be changing the name to anything? My second thought was, well, maybe they meant to do this in Mr. Fox's case. Maybe Mr. Fox is having a preliminary hearing on Friday and they just used Mr. Robinson's form as a template and they forgot to change the caption. That kind of thing can happen too. The error can happen both ways. But then we got that confirmation from the detailed court docket that no, they are in fact having the closed hearing at that time in this case. So it's not something they scheduled to happen in Mr. Fox's case. That time is already allocated. That time is being spent in Mr. Robinson's case. So what does this mean? Wouldn't it be nice to know if the state is on the one hand saying this guy commits these types of crimes, and on the other hand, through the other side of its mouth, saying you should totally believe him about potentially maybe things he has to say about Tyler Robinson? Do you think a guy facing charges like that, is there anything he wouldn't say that the state wanted to hear to try to get himself out of his own jam when you're facing a charge like that? This guy is not going to have private OPSEC information about sheriff's office procedures, policies, protocols, plans, security measures. He's going to be a guy who heard something. Like, that's it. My guess, like I said, I think fairly informed speculation, but still ultimately just speculation, would be jailhouse informant. He heard stuff at the jail. I've seen some people suggest, oh, maybe a Discord connection. Maybe. If the security measures and the risk to security is what justifies closing the public hearing, this guy doesn't implicate that. He does not implicate OPSEC. So I'm really failing to see the justification for closing the hearing for something like this. Don't we, the people, have a right to know what exactly is your position on this guy? This witness, apparently? Or if it's just a mistake, great. That'd be awesome. That would really be fantastic if this were all just a big misunderstanding. But we won't know because we can't watch the hearing. So see, this is a big part of the problem. When you close the court process, you delegitimize it. Because we can't see it for ourselves and judge for ourselves. Sorry, you're in America. Sorry, not sorry. That's one of the principles that we have here, is that we get to evaluate how our government is doing its job, in part because we're the ones who are responsible for voting them in and out. And so we're entitled to know about the decisions our prosecutors are making on our behalf, in our names, state of Utah. We're entitled to know what they're doing. We're entitled to know what the judge is basing his decisions on. If you're listening to this guy and you're finding him credible, we're entitled to know that. This judge is going to stand for a retention re-election some point. We'll talk about that in the future, probably. So when stuff like this gets done behind closed doors, it kind of tends to jeopardize your ability to evaluate, is this appropriate or not? Are we doing this right or not? Is this the kind of decision that I would want to be made? Is this the kind of evidence I would want decisions like that to be based on? We don't know. We don't know, because they have closed the courthouse to us today. But guys, that's okay. All is not lost, because they're going to come back on Monday, October 27th, 1 o'clock, for a ruling hearing. This is being designated as a ruling hearing. Monday at 1 o'clock Mountain. So that's going to be noon Pacific, where I am. So I am planning to live stream again for that. And part of the reason why is because we do know already that it's going to be televised. It's been a request for order already in October the 27th at 1 o'clock, and the request has been granted. So news media is going to be in. They're going to televise it. So yeah, we'll be back on Monday to stream it and see if hopefully we get some answers to some of this. See if maybe kind of like they did the CYA court minutes on that hearing, that telephone conference that they had that they didn't record. Came back after the fact to kind of CYA, well, for the record, here's what we did. We'll see to what extent they do that with this hearing that they've closed to us. fill us in on what went on behind the scenes that we weren't allowed to know about? And I gotta tell you, I have big questions about Jaxson Fox. Big questions about that. Because I want to know if the prosecution is relying on somebody with that big of a motive facing those kinds of charges, and based on the allegations, he hasn't had his trial yet either. He's still presumed innocent. But let's just say if the prosecution is going to be able to present in court the evidence they say they have, yeah, it's going to be ugly. It's going to be quiet. It's not going to go well for that guy. So big incentive to make the state happy, give him whatever they want if it might benefit him. Yeah, I kind of think we need to know that. If jailhouse snitches are going to be part of the policy of this prosecution, I want to know, because that is definitely going to color my perspective on how committed we are to a fair process. Going to have serious questions about that. So guys, that's what I got for you today. Little more than I had expected, for sure. I guess I ended up leaving that Substack banner up there the whole time. I'm going to take it off now. Yeah, lot more going on than there was when I first set up this stream and thought this would just be a leisurely stroll through the briefing on shackling and civilian clothing. We don't even really get to do the both sides review because, of course, the state's response is private. We don't actually even know what their position is. We don't even know what the state's position is. Since the whole thing is private. I don't like that. I don't like that. It's very, very hard to evaluate your public officials when they are doing things that they don't have to reveal. They don't have to let us in on what they're doing or why. And if we don't know what they're doing or why, then how do we know if we want this person as a public official? It's a big problem. It's a big problem. And just becoming more and more prevalent in these high-profile cases to try to do more stuff behind closed doors. I don't know how much of that is self-interest, self-preservation. We don't want to be criticized. Like, believe me, I'm very sensitive to the whole concern about the right to a fair trial and the tainting. The problem, though, is that the tainting is really an issue when you're only getting one side of things. That's the issue that I have with the gag orders, is because we have already heard one side of things. And that's all the jury is going to hear, the prospective jury, the potential jury. When there's a gag order, that's all they're going to hear is one side of things up until they end up in that courtroom being sworn to decide it. Not saying cases should be litigated in the public square, but it's having both sides of the issue be presented. That's what helps make sure your jury isn't tainted. So, just the more you do stuff behind closed doors, the more distorted that perspective is going to be. So guys, with that, I'm going to turn to your comments. There are a few of them today. We got a couple of new members. I see you as a new member, and Michael Muddragon has gifted some memberships. Good to see you back, Michael. It's been a minute. It has been a minute, hasn't it? Mad World is here. Support for the Brilliant Blues in the chat. Thank you for that. We do love our chat here. You guys everybody always says that they have the best chat, but I'm just here to tell you, like, it's you guys. We all know it. I always wish I get to read more. That's why I love that we've got the chat replay now on YouTube. I can actually like go back and catch up on the chat from time to time. All the abundant free time that that we have. But I know sometimes like Jeff will tell me, oh, there was like, something happened at one point, or there was this clever thing, or just whatever. It's good to be able to go back and see what everybody else is thinking, especially because it's just my favorite thing. We have so many good brains in this chat. We got a lot of smart people, very educated people, bringing a lot of different background and experience to these cases that we're all interested in. So it's a great group mind kind of project. Mavka, Law Mom, why do they make this kid wear the turtle suit if they want to off him? To waste money? And thanks for the crypto tips. I invested my 401k. Yeah, no crypto. I promise you guys, I will never advocate for crypto. You will not see posting like that from me. I'm not saying that there's no room for any crypto whatsoever in a well-balanced portfolio. Everybody has to evaluate the risks and benefits of different investment options for themselves. But yeah, the whole like let's invest our whole life savings in crypto. No, you'll never hear that from me. Come on, like, this is a smart channel, guys, not to pat myself on the back. This is a smart channel. Like, you're going to hear about modern portfolio theory here. Like that's what you're going to hear here. You're not going to hear like put your whole life savings into crypto. They put the kid in the turtle suit because it's policy, and because they don't actually want him to off himself. There's going to be a lot of different actors that have different motives. So, are there people collaterally, directly, whatever, involved in this case that want him to off him? Maybe. But the sheriff doesn't, because it's extremely embarrassing to the sheriff if that type of thing happens. And the sheriff is potentially liable if that happens. You can get sued. You can get sued for not exercising precautions. So it is in their self-interest to keep him going through the process. And the reality is, yeah, if they have a case, everybody wants that to be brought out in court. Everybody wants the opportunity to show your goods. If you got the goods, you want to show them. That's why it was so telling when Mr. Thompson over here in Idaho went and ran to the grand jury instead of having a preliminary hearing in the Kohberger case. Preliminary hearing, show all your goods to the public. If you got them, that's what you want to do. But didn't seem he wanted to do that. This case so far, I mean, can't say they aren't going to play that same game. Certainly hope they don't. It's going to say a lot if they do. But defense has asked for the preliminary hearing. They want the cards on the table. You would expect if the prosecution has the cards, they want to play them. So we will just have to see how that unfolds. Sarita Banana is back. Good to see you, Sarita. Welcome to your membership. Shan M is a new member. Good to see you, Shan. Claude Simeon, the day will come. You want to tell us about your great financial advisor. We'll never believe you. Must include kitty pics if you do that. I don't expect to ever become a finance kind of channel. That's just not my thing. If we ever talk about that, we'll talk about it collaterally. The one thing I guess I'll share, because I enjoy it. I find it amusing. I married an MBA, right? Jeff has that financial background, and so I've learned almost everything I know about that type of thing from him. And he's kind of a smart guy, you might have noticed. But anyway, he has a story that he told me, a long time ago when I'm kind of first learning about like diversification. What does that mean? Why do you do it? Stuff like that. And the idea is just basically, the more you can diversify your investments, the less risk that there is that, something goes south. It's not going to tank your whole portfolio. You're not going to, lose everything because the stock market took a little bit of a minor downturn. It's kind of like complicated hedging, but you do that on many different levels, not just between different types of investments, but also like, so between like stocks and bonds, and, hard assets, real estate, gold, whatever, but also like different classes of assets within that. So like even in the stock, I'm not going to like buy all one stock. I'm gonna buy the index fund. I'm gonna like buy the whole. I'm gonna try to buy the market. That's gonna get you more diversification. That way, if large caps fail, that's fine. I've got plenty of stuff in small caps. I've got plenty of stuff in emerging markets. It's not gonna tank my whole investment. But anyway, and the reason why that came up is because we're kind of chatting about like investment advice and stuff that people get, and like people always got the hot stock, or like now it's the crypto, put everything in the crypto, or it's this coin or this other thing that's going to be the big get rich quick. And for some people it's real estate. Real estate has been a big, sort of common one. And we would see that in law practice with folks like we're doing estate planning for, and they'll have, multiple like rental properties or things like that. And anyway, there's a saying that Jeff attributes to one of his, I think, finance professors, that I never had to clean cat piss out of my brokerage account. So it's part of my perspective on investing. Do try to not have to clean cat piss out of your investments. But of course, now I got 5 of them around, but they're pretty good with the box so far. All right, speaking of, give me half a second here. Kitty pics. We got some nappers down here in the they're actually laying there on the dog bed with the dog. The dog sits behind me while I do these streams, and the cats have decided to join her over there. So I got a little Gus here, is quite a good sleeper. I don't know if you can hear him, but probably not, but he's purring away here. And I got little Corona over there in my little St. Joan. So here they are. They're like getting bigger pretty much every time I turn around. They put on like a pound this last week, but they only weigh like just over 3 pounds. Like, it's kind of crazy how fast they're growing. So guys, the amount of cat food we're going through is a little bit off the hook. So, hey, I'm going to be spending some time with the kitty cats now. And it's getting to the weekend, guys. It's getting to the weekend. What's going on for this weekend? You guys got some good stuff going on. I know there's football. There's always football. We got some boxing. We got some fights over here in our neck of the woods. Got some kids that are going to be going and competing. So have a little bit of that going on this weekend. And otherwise, I'm probably chasing the monsters and just enjoying what we got left to fall. It's going to turn to winter very quickly. Already a little shocked at how dark, long and dark the nights are getting. The days are getting so short. It was like 7:15 this morning when I went outside, and the sky, it's all pink in the sky. Beautiful sunrise, but I'm like, it's 7:15. Like, what? This is crazy. That is a late start to the day. So, just wanted to give everybody the little kitten update while we had a chance to do that. So with that, guys, I'll be back on Monday. It'll be probably about 11:30, 11:45 my time here, Pacific time. We will be aiming to stream this ruling hearing that has been set in Mr. Robinson's case. And then, of course, we have the other hearing that has already been scheduled for a while on the 30th, October the 30th. That is to reset the preliminary hearing. That one, may not be very interesting from a, substantive standpoint. If it literally is just a scheduling hearing, it might be kind of boring, but, you just never know what's going to happen in court. That's kind of the challenge. You think it's going to be boring, and then some crazy stuff happens. You think this is just a routine motion to get this guy out of his shackles, and boom, it reveals all of these issues that are going on with administrative sloppiness and public access and so forth. So I would just rather be here and be wrong and be bored with all of you guys than potentially miss out something important that's happening. So I will be back on Monday. Summer is enjoy your laugh, perspective, insight, and kittens. Well, thank you, Summer is. I always appreciate seeing you around here as well. So many familiar names. Guys, I know I shared with you like the whole X thing, and a lot of you here on YouTube are not on X, and I will never criticize that as a life choice. That is probably the better one to have made. But for better or worse, I have been on X for a good number of years now. And so when I did lose my account, part of the reason why I lost it was, I didn't have the two-factor authentication on, because I'm like, it's just X. It's just X. It's just a stupid social media, where you say random stuff. So like, who really cares? It's not like my bank account or anything like that. Well, then of course, as soon as I lose it is when I realize, oh my Lord, I got so many people that I don't have any other way to connect with. And when I didn't have that, that was like the worst part of it. Was just being worried that number one, like, the person who hacked me is going to go after the people that follow me and trust me, but also just that I was going to lose all those relationships and, parasocial stuff and whatever. But, some of them are strong. Some of them are really valuable. So I really had a wake up call with, I either need to take some more steps to have, real life ways to communicate with some of the people that matter the most. But also I set up my two-factor authentication. Okay. It's worth the pain in the butt to not have to go through that again. So that those of you that I chit chat with on different platforms, we don't have to lose out on that. So Raymond Knopp. Tyler Robinson smiled in court and he doesn't talk. Something gives me the idea he's waiting till the very end and he'll burst the bubble totally wide open. If he's got something, it is almost always something that you are never going to find out until the last minute, because the defense rarely has any advantage from showing their hand ahead of time. They don't have to. They don't have to show their hand ahead of time. They don't have to say if he's going to testify. If he is going to, they don't have to say what he's going to testify about, other than their just nominal discovery requirements. They have to identify their witnesses. They have to identify their exhibits. It's just, typically a variety of fairly specific information that they have to provide in advance of trial, but they don't have to reveal their strategy. And, the defendant's right to not incriminate himself, his privilege against self-incrimination, Fifth Amendment right, means he doesn't have to testify, and he gets up until like literally the last minute at trial to decide if he's going to do that or not. So if he has something in his back pocket, yeah, we're probably not going to hear about it until the absolute last minute, because that would just be more in his advantage. Why would you show your hand to the prosecution so that they know how to work around it? You don't do that. It's one of the very few structural advantages that the defense has in the criminal process. All right, guys, with that, yeah, Plenty of stuff still going on, plenty of stuff more to talk about. Next Monday, we'll be back. Next, what is it? Thursday? Can't even remember now what our dates are. The 30th. Yeah, 30th is next Thursday. So Monday, Thursday, we will be looking at some of those hearings. I will be aiming to get something up about the judge, the kind of research I've been doing into the judge and a little bit of that context. I'm going to dig into the legal teams as well, like I said. So just to get us a little bit of background information to know who we're dealing with, and maybe help us predict a little bit of what we're going to see here. And then just, at this rate, there's going to be pleading after pleading after pleading. There's already some here on the docket that are worth sitting down and going through. Motion to preserve evidence and the state's objection to it. That's one. It's very short, but it's raises some interesting questions about why would you be having a problem with this? And then just as it gets more and more into the discovery process, there's likely to be fights about, what needs to be revealed and what doesn't. So those will start to give us a little bit of insight into what the evidentiary case for Mr. Robinson's guilt is going to be, what the state is going to say that they have to prove it. So hopefully we'll have a preliminary hearing soon as well, and that will definitely go a long way, I think, towards answering some of the questions, the many questions. I certainly had plenty when I read through that probable cause affidavit, and so we'll hopefully get closer to having some better perspective on what we think happened here. So, guys, with that, do enjoy your weekends. If you can, highly recommend some time outside. This is actually one of my favorite times to be outside because fewer people start to be outside. So you get a lot more places to yourself. It's kind of nice. I don't know. I kind of enjoy that kind of thing. Been taking the dog out to walk, long walks lately. Try to wear her out so she doesn't harass the kittens quite so much. So, yeah, guys, look after yourselves. Take care. Enjoy your weekend. Have some fun. Spend some time with the people that matter to you. Do all those good things that feed your soul. Keep your life full, happy. And the things that matter more than, not that this case doesn't matter. The case matters. All the cases matter. But you got to put your oxygen mask on first, as they say. So with that, guys, I'm out of here and I will be back. Hope to see all of you Monday morning. Take care, everyone.